C'est une séance assez exceptionnelle de penser le droit social aujourd'hui, avec, vous le savez, on peut dire, je pense, l'une des plus grandes figures du droit du travail au monde, Matthew Finkin. Donc je pense que tout le monde le connaît, c'est un peu une star du droit du travail, donc on est vraiment très heureux de l'avoir avec nous. Donc il est professeur à l'université de l'Illinois. Il est le directeur de la Comparative Labor Law and Policy, enfin on peut dire, Comparative Labor Law and Policy Journal. Et c'est quelqu'un qui écrit énormément en droit du travail et qui a des publications très importantes. Donc on est vraiment très heureux qu'il soit là. C'est la deuxième fois que Matthew Finkin intervient ici à la Sorbonne. Hein. Il était là il n'y a pas si longtemps. Donc voilà, c'est vraiment un plaisir, Matt, de t'avoir avec nous. Alors, pour parler d'un sujet, alors je suis absolument désolé, il y a une petite erreur sur le site qui m'incombe complètement. C'est pas qui est l'employeur, c'est plutôt qui est le salarié. Donc, on va dire c'est quasiment la même chose. Voilà, c'est ça exactement. Mais bon, les deux se rejoignent finalement. Les deux se rejoignent finalement. Donc Matthew va parler en anglais, même s'il comprend
quelques mots.
Voilà, il est modeste, mais il comprend le français. Il parle aussi le français, mais je pense, on va jongler entre l'anglais et le français peut-être dans nos questions.
Lentement.
Voilà, mais il y aura quand même pas mal d'anglais. Puis c'est finalement pas mal aussi d'avoir une séance de pensée de droit du travail qui soit largement en anglais.
Pascal asked me to speak slowly in English. C'est très difficile pour moi because I was born in New York. And New Yorkers speak very quickly, but I will do my best. I was asked to address an issue of American law, U.S. law, that resonates with you here in France and more widely in Europe and other parts of the world, largely driven by the public prominence of the rise of the so-called gig economy. We can get back to that at the close. I think that the celebrity of this development is not deserved, that there is a lot less there than meets the eye, and I can explain why when we get into that. But it raises this question of who is an employee. And the title of the talk is, Why Does It Matter? It's best, I think, to address the why first. Why does it matter whether someone is called a worker? Someone who does work is called an employee. In the ancient world, okay, I cannot help being a professor, and so I speak with footnotes. My research for the past 2 or 3 years has been in waged labor in the ancient world. I had a naive notion from my high school education that the ancient world was, as Marx called it, Asiatic despotisms, the Asiatic mode of production. It's not true. There was a lot of waged, free, voluntarily engaged in waged work in Babylonia of the Third Dynasty of Ur, in Pharaonic Egypt in the Ramesside period. Then you move it up to Rome, to Greece, classical Greece, and then under Seleucid rule in the Middle East, Ptolemaic Egypt, Rome, Han Dynasty China, the same period. The word in the one book I said was KUQ. I don't know how that would be pronounced in the tongue, but hire, to be hired. Okay. Yes, wage labor was not a foundational institution. It has become so under capitalism. But it was a significant institution, and in many countries more significant than slavery. Slavery in ancient, I'm getting off into Babylon. But the point is, there was a contract of labor, of hire, and it was hire. That is to say, a lease. You leased a worker. Personenmiete, Miet in German. In English, a hired hand. You hired. We still say for hire, work for hire. You hire a cab, you hire a hotel, you hire a worker. There, with one exception that I'll mention, there was the lease of a worker was not. There was no distinction according to the manner in which the work was done. In other words, there was no distinction between an independent contractor, a petty businessman, and an employee. It made no difference. Now, I have not studied Roman law as a student. Every American law faculty used to have a Roman lawyer, and that went out by the time I became a law student. But I've had to look at it, and the contract was locatio conductio, as a contract of hire. The glossaders of the Middle Ages, of the High Middle Ages, drew a distinction, locatio conductio operar, oparmo locatio, right? To hire the worker to do something as opposed to hiring the worker to perform, to make something. Right? Independent contractorship. And many European legal systems, France does, and the German Civil Code starts out with that. But this was a Middle Ages theoretical operation. In classical Roman law, they didn't care if you were, and if you hired, in one text, if you hired someone to pick your olives, was he your worker, or was he an independent contractor? Roman law didn't care. The contract made no difference. In that time period, and so we're talking about the 1st century before Christ and the next 2 centuries after, the late Middle Ages, late antiquity, Bingham calls it. There's only one polity that did draw that distinction, and that was Jewish law. Jewish law was just different from, I've found, from everybody else. And they drew the distinction between an independent contractor and a worker. Now, why? No one else did. The Jews were always very, the rabbis were always, the sages, as they said, were always very cognizant of the flight from Egypt, of slavery, of the role of slavery, and they were not happy with it. There was slavery, but it had lots of restrictions. And to the sages, an employee hired to do something had no control of his time. If I hired you as a drayman to take my daughter to her wedding, you had to show up on time and perform the task. If I hired you to make a ring for me, well, you did it in your own good time. You controlled your time. And the worker was more like a slave, even though it's a free contract. The difference was then in Jewish law that the contract of hire was revocable. While taking your daughter in the cart to her wedding, the drayman could say, I'm not going to do this anymore. I quit. And that was not a breach of contract. because the contract was, unlike the man you hired to make it was slave. So there are lots of responses. Well, what if he says, I quit, but if you give me 2 shekels more, I can finish the job? And the sages said, well, you didn't promise him the 2 shekels, but you don't have to pay. Because in modern economic terms, he would be considered opportunistic. Right? There's a lot of law there. Right? It made a difference, the status of the person, for the legal consequences. But that's not so. Now, in the Middle Ages, when the glossators, was it so? I've only found one case where it makes a difference. I'm telescoping why it makes a difference today. It makes a difference today because we have a lot of labor protective law. And in order to qualify to be protected, you must be what? An employee. So it's important for us to know who you are in order to decide whether you are entitled to this protection. So that's why it's important. But this is a very recent legally phenomenon. The only case I've found so far is a decision of the British Court of Common Pleas in the late 14th century, where under the statute of laborers of 1350, a laborer could not quit. You all know the history, and because of the Black Death, the population in Europe fell by about 30%, depending on where you were. And this gave workers, peasants, employed peasants, considerable bargaining power. So they would quit. They would demand to eat meat, right? Not barley, not malt, but not porridge, meat. Piers Plowman, if you've read that poem, these workmen are demanding beer, and they won't work unless we feed them meat. Only nobles ate meat. So the statute of laborers clamped down supposedly on employers too, but really on work. Wages were fixed, and they couldn't, among other things, and they couldn't quit. And here's a case of a petty baron who hired a chaplain to sing masses for him, to be his chaplain, and he did it very well because another nobleman said, "Be my chaplain," and this chaplain quit, and his employer said he can't quit. He's restricted by the statute of laborers, and he says, "What? I'm not a laborer." It's the same kind of question. And the court said a priest is not a laborer. Right? Whatever else, he would be what? An independent contract. So why did it matter? It mattered, and this, again, I'm going to speak in footnotes. I'm only speaking about American law, U.S. law. I'm not making even a suggestion of its portability. It is sui generis. This is the way the U.S. does it. As in much of labor and employment law, we are in silos. Europe is not, because there is European labor law, right? The European directives and privacy regulation bears no resemblance to what the United States. The United States no longer looks abroad. It used to, but it doesn't. I'm describing a world that may sound like it's coming from Mars. I've been teaching in Italy for the past 4 months at Bocconi University, and I taught at Padua, where Galileo taught. I used his lectern. And he wrote a book called The Sidereal Messenger, and I said, I'm the sidereal messenger. I'm going to describe law on Mars, which bears no relationship to anything. Our law of arbitration, for example, is completely unthinkable in the European context. Less so maybe some of the stuff we'll get into now. The distinction drew importance in the wake of industrialization, not of labor protection law, but of tort law, Delict. Population boomed, industry boomed, more and more enterprises, and as enterprises are conducted, what, statistically, there are more and more accidents. Third parties are injured in the course of a company doing its business. A simple case. Newspapers, when we had print newspapers, would be sold at kiosks. They're called newsstands in the U.S. Kiosks. The truck with the newspapers bound in copper wire would drive by the newsstand, and the bale is hurled out at we call them newsboys, but they're older people, very often immigrants who bought this kiosk and they're in business. And in throwing the bale out, there's a 5-year-old kid walking along and gets hit by the bale and is seriously injured, maybe killed by this accident, by an act of negligence. Who's liable? Is the newspaper company liable to the parents for the injury the bale thrown out by the driver did? English law on this was at 6s and 7s for 200 years. The cases are all over the place. I can give you one. I would have to diagram one case. It's the most complicated. Whether you have to go down 3 chains of supply to say, is the guy who built his house liable for an accident that occurred? It's a 1797 case, and the British court said yes, he is. It's impossible to know why. And that became American law for almost 50 years, groping for some basis. Ultimately, the rule that emerged, I think in Britain, but adopted in the United States, is that it took the Latin name of respondeat superior, ask above, that the injured party could sue an employer for the negligence of its employees when they acted within the scope of their employment. Now, that was a controversial rule. There was Oliver Wendell Holmes, that's a name some of you may know, okay? He was a professor of law at Harvard and then a justice of the Supreme Judicial Court of Massachusetts for decades. When he was 60, he was put on the U.S. Supreme Court, very distinguished jurist, on the assumption that he'll not be on the bench for more than 5 or 10 years. Of course, he stayed for 30. He retired at 90. But Holmes wrote an article when he was a professor on this notion of vicarious liability. And where this line, he would have none of it. Harold Lasky, the British socialist, said, you're just, all of this is judge-made law. Why your employee? I mean, if I hire a cartage company to deliver my papers, and the cartage company's employee hits the kid, I'm not liable, because what? It was an employee of an independent contractor. Lasky said, what's going on? What sense does this make? It makes no sense. It's simply a way of, now, Judge Easterbrook later says, well, we assign liability, tort liability, to an employer, not to the purchaser of the services of an independent contractor. Because an employer, we assume, is responsible for the selection and training of the workers. And to hold the employer responsible means the employer will do its job of training employees. But other people have said there is a responsibility of investigating your contractors. So what's the difference? If you are in the school of law and economics, early Guido Calabresi, the very early cost of accidents, the question would be, well, who is the superior risk spreader? Should the kid have been a self-insurer? Because insurance makes all the difference. Who should have borne insurance against the risk? That's the real question. It's not a moral question. It's not a religious question. Some people, there is some warrant that you are liable morally because you set the chain of causation in motion. That's this Brit who built a house, and through all these chains of supply, he's liable for where the employee of a contractor of a contractor of a contractor stacked some tiles on a road because morally he launched the enterprise. So it's for that purpose that the question of who's an employee and who's not an employee, for the purposes of tort liability for negligence. That's the origin. The American Law Institute, I don't know if any of you know what that is. No? The American Law Institute, the if you go into the library, if you research American law, you'll find a set of documents called the Restatement of Law. Restatement of torts, restatement of contracts. These are produced by a private organization called the American Law Institute. It was created in 1927 by a bunch of graduates of the Harvard Law School in reaction to legal realism then being taught at Yale. We're not like Yale. They say it's all politics and sociology. No, doctrine makes a difference, right? It's, for those of you who studied American contracts, the difference between Corbin on contracts, he was at Yale, and Williston on contracts, he was at Harvard, right? So the Harvard people came in, they created a self-perpetuating private organization. It's private. It's as close to the academy as you can get in the United States. Right? De haut en bas, they tell us what law is. And they hope that the court, what the common law is. And they hope that the courts will follow. And in this area, the courts have. And the restatement, I sent an outline. Was this circulated, Pascal? Okay. Well, it will be. I mean, it'll be available. Yeah. You have to look at what the restatement did. It says, it's in the restatement of agency. Who's your agent? And it gives, it says, in determining whether one is acting for another as a servant, you'll notice this is 1935, as a servant or an independent contractor, the following matters, among others, so it's open-ended, are considered. The extent of control the master may exercise over the details of the work, whether or not the employee is engaged in a distinct occupation or business, the skills, 18 non-exclusive questions. This is what the economist Peter Steiner, in a private conversation, late Peter Steiner, in a private conversation with me, described as a calculus of variable weight. Namely, it means nothing. Any one factor can be, this is very important that of the length of time the person is employed. Very important. Next case, well, length of time on this case isn't all. It's a totality of these considerations. So I hate these totality tests. They tell you nothing. They're like making an army soup. You put in all the ingredients and stir, and this is what comes out. But that is the common law way we approach, well, are you an employee? We have 18 factors. All the courts say, well, we just don't tally them up in columns. This favors employee, this favors independent contractor, issue by issue. And then we see how many count. 18 or let's say 20 factors, 15 or 12 against 8. We don't do that. Actually, that's exactly what they do. They say they don't. But if you read these cases, that's what they do. That's the background of where this employee independent contractor in American common law came from. Now, why does it matter in settings other than torts? We have two systems of law in the United States, federal law, which is supreme, and then each state has its own set of laws and its own common law. As my students in Germany tell me, how do you teach this? German law, as in France, is a unitary system. Must you know the law of 50 jurisdictions plus federal law? And the answer is yes. If you practice law in Illinois, you need only know Illinois law, but if you teach, then no, that's not for me. So in federal law, the federal law of wage and hour, that is to say, minimum wage and overtime, and child labor, was enacted in 1938. So it's important to know whether you're an employee or not for wage payment laws, wage and hour laws. In 1935, we passed our collective bargaining law. Employees collectively bargain, and amended, as I'll get to, in 1947. Starting in the 60s, we have a lot of anti-discrimination law. Sex, race, religion, national origin, and now age, handicap. There are, and at the state level, it's an ever-growing laundry list of non-discrimination against whom in employment? Against employees. Who's an employee? And we have a whole raft of anti-retaliation and whistleblowing laws. All this is federal law. We do the same. It's replicated at the state level. Child labor, wage and hour, minimum wage payment, overtime, scheduling of work, unemployment compensation. Employees get unemployment compensation. Independent contractors do not. Tax purposes. An employer has to withhold your income tax payment and has to take Social Security payments for employees, not for independent contractors. Independent contractors have to file their own taxes, and they don't get Social Security. So what the takeaway here will be is that each of these legal regimes is a silo of law. Who's an employee is determined for the purposes of this silo, of this statute, of this system only. As we'll see in a moment, you can be an employee for wage payment purposes, but you don't have a right to engage in collective bargaining. So you may have a right to your wage as an employee, but you can't bargain to improve your wage because you're not an employee, because different statutes have different tests. Let's start with, I just want to run through some of this, and then I think we can wrap up and get to questions and discussion. Child labor. By the way, I talk to my secretary every day. That she keeps me posted as what's happening, and there's been a whole lot of activity by the U.S. Labor Department in bringing lawsuits for violations of child labor. We had all thought child labor was something we solved. It's not true. There's a lot of abuse of child labor. Child labor is a fascinating legal conundrum, because a minor, a child, can't make a contract, can't be a lawful employee under. So who is the employee? It can't be a child. Some states, in this period, the turn of the 19th century into the 20th century, the father was owed the services of the child. So the father could contract for the child's services to an employer, and the employer paid the father. Sounds very much like the leased worker problems that we have now. It's nothing new. This is almost 200 years. Oh. Or what do you do about this problem where very often a child would show up and say, let me assist you. And the worker would say, okay, kid, I will pay you. All right, the work is being paid. He, the worker, just a worker, hires the kid. And then something happens. Is the employer, who's the employer? That's the other question. Many states had adopted this test that to be employed is to be permitted or suffered to work. Permitted or suffered. Now, permit, I think you all understand, yeah? To suffer, well, in the New Testament, Jesus said, suffer the little children, right, to be brought to me. Suffer is different from permit because it is to be allowed. In other words, if the enterprise owner permitted the child to work, or even allowed the presence of the child as a worker, because he had no contractual relationship with the child, his worker did, that entity, that employer, would be liable under the child labor laws as an employer to the child. It's the broadest possible notion because it doesn't require a contract. It doesn't require, it has none. And this became so in many of the state child labor laws, and it will be, and it was adopted as the general test for federal wage and hour law, for minimum wage and overtime law. I'll come back to that. Collective bargaining. The National Labor Relations Act of 1935 said an employee is a person who's employed. I didn't make this up. It's a circular definition. To be employed, and a person who's employed is an employee. In 1946, the case came before the Labor Board that, in the first instance, decides these matters. Remember I said the people who own these kiosks, who buy, right? Remember the newspaper bundle? Does that resonate? Okay. Each of these people, they own their little kiosk. They buy the newspaper, let's say the Chicago Tribune. The Tribune truck comes by, 100,000 papers are dropped at the owner pays 5 cents a copy to the publisher for the paper, sells it for 7 cents. What he doesn't sell, he sells back to the company for 4 cents. Their contract is a boilerplate contract. Sign it here. That's all the newsies, these kiosk owners, and they're older people, and they all get together and they say, this 7 cent, this arrangement, we're taking home virtually nothing from this. We want what? We want 10 cents a paper. We want to bargain collectively with the newspapers. Well, the newspaper says, we're not going to bargain with you. We're not going to bargain. We don't have to bargain with you because the law says we have to bargain with employees. You're not an employee. The Supreme Court, 1947, the Supreme Court said the question of whether they're an employee is a question is, are they employees for the purposes of collective bargaining? That question is determined by the economic relationship to the company. Are these people so situated vis-a-vis the lead entity that the statute meant for them to be able to pool their bargaining, individual bargaining power, and bargain as a group? That's the test, not the common law test. At common law, this agency test, were these newsdealers employees, do you think? No. They own their own, they were petty entrepreneurs. They own the kiosk. They have a contract to buy the papers, sell their papers. They own the paper. And sell it back. By any notion of their independent, they're petty bourgeois, they're petty business. But the Supreme Court says for labor purposes, they have to be treated as employees. Well, in 1947, the U.S. Congress, a Republican Congress, reduced the power of the Labor Act. Didn't repeal it, but they cut it back significantly over President Truman's veto. And that law is the law that still governs the United States today. It's been proven to be impossible to amend, to change, because of the politics of our Congress. Footnote, you need 60 votes in the Senate to close debate. The Democrats, which are now firmly allied with organized labor, don't have 60 votes. I don't think they will in my lifetime. They may have a majority, but under Senate rules that won't. This law, we live with a collective bargaining law that was enacted before we had a federal highway system, before this was invented. You know? The law was designed for factories of the 1930s, not service enterprises of 70 years later. But that's the law we live with. Congress comes in and amends the Labor Act in 1947 as part of a larger rebarbative, regressive legislation, and says employee, same definition, but no employee, no independent contractor shall be deemed to be an employee. It's in the statute. And what they meant by independent contractor is what? The common law, the agency, the American Law Institute's definition. So here we are. There is a case that just was decided by our labor board, which is now in Democratic hands, and the oscillations of the readings of this very flexible statute now is 180 degrees back and forth between Republican presidents and Democratic presidents. It's unprecedented historically, just unprecedented. Exotic dancers, which is something of a misnomer. The popular phrase is what? Strippers. Not being, I don't denigrate an honest occupation, right? And they come to the club, they have to be approved by the mother, the house mother. They are subject to a dress code, they're subject to a deportment code. They have their own attire or lack of it. They pay a fee to the house mother. They pay a fee to the DJ that plays the music. They pay a fee to the security guard. They are allowed to use the pole, and they have to give the house 25% of their tips. Their income is from tips. They can come and go as they please. They show up, do you need me today? Fine. If not, no. Some will show up once a month. Some will show up every day. They have formed a union. Are they employees or independent contractors? I think the conventional wisdom would be, for the purposes of the Labor Act, because of that amendment, they would be independent contractors. But this labor board, the Biden labor board, has said, no, they're employees. That case obviously will be appealed. But, okay, That is the law of collective bargaining. And there is a lot of law involving Uber, Lyft, FedEx, Federal Express drivers, who they have to own their truck. They wear the shirt with the FedEx logo, but the labor board, the Obama labor board said they were employees. It's true under their contract they can sell their route. They're not scheduled. They set their own schedule. They set their own schedule. But the deliveries must be made and picked up, whatever the schedule is. Right? It is obvious. In one case, the Federal before the Supreme Court of Kansas, there's something like a 20-page, single-spaced, tiny contract detailing all of this. And the Supreme Court says to FedEx's lawyer on oral argument, you just need a package picked up and delivered. Why all this law, all this, just to get a package delivered? And he said, we don't want them to be employees. Why? Well, because we don't have to pay unemployment insurance. For all the reasons, right? The labor board said these FedEx drivers can sell their route. Only 3, and in a terminal of 270, only 3 have ever done it. The company must approve. And if you sell it without the company's approval, you've got no route. So it's worthless. It's worthless. The Court of Appeals said, oh no, they have entrepreneurial opportunity. That's one of that list of 18. Oh, they have entrepreneurial opportunity. The labor board, the Obama labor board said, no, they don't. Back and forth. The Trump board said, oh, they're independent contract. Now the Biden board has announced they're going to reverse that decision. So, for the purposes of collective bargaining, we get, for wage and hour law and for some of the other statutes I've talked about, the wage and hour and wage payment law, federal and many states follow the suffer or permit test, which all the courts say this is the most liberal test. This is the most liberal test that federal law provides. Respectfully, that's nonsense. Because when you look at what they do with it, they say, oh, there are not 18, there are 6 factors to suffer or permit. The nature and degree of control, the employee's opportunity for profit or loss, the employee's investment in equipment or material, whether the service requires, it's the same multi-factor. It's got fewer factors, but what makes this especially liberal? So there is a case of the pickle pickers in Michigan. Michigan grows a lot of cucumbers for pickles. This is the deal. Mr. Flores and his family, these are migrant workers. Mr. Flores and his family they've come to the pickle farm every year. And the farmer says, okay, I will lease you, how many hectares do you want to work? Do you want to lease? 10, 20, whatever, 20 hectares. Fine. This is the price. You lease it from me. You supply your own equipment, a knife. That's your, you supply your skills, picking cucumbers. We supply the buckets. You're not obligated to pick a single pickle. But if you do, we will market them. You get 50% of what the pickle sells for, and we get 50%. The Court of Appeals for the for the 7th Circuit, Illinois, my court, covers Illinois, goes through these 6 factors and says, well, they are employees. They're not independent, but it's close, isn't it? Because they lease the land, They have their own equipment. They're highly skilled. Judge Estabrook, who's a former University of Chicago law professor, a major figure in law and economics, particularly antitrust, had a concurring opinion where he says this is all nonsense. We shouldn't be doing any of this. All these people are doing is selling their labor. If they had a piece rate system, if they work harder, you get more per pickle. I mean, so what? Or if it's a commission, they said, yes, but they have risk, they have entrepreneurial risk, because the pickle market might crater. And he says, well, if you're paid on commission as a salesman in a clothing store, the blazer falls out of fashion. That doesn't make you a petty businessman. You're still an employee. In any event, for wage and hour purposes, federal wage and hour, and some states, it's that kind of analysis. Anti-discrimination law is federal anti-discrimination law is pretty categorical, that it adheres to the common law definition. Now, that's kind of interesting. I mean, if I am a woman and I want to be treated by a female doctor, that's my choice. I mean, I think the popular conception is that's your choice, that's your freedom as a patient, even though you are making a contract of independent contractorship. But if a company hires doctors as employees, they cannot discriminate. They can't say, well, we don't hire Muslim doctors. But if it hires contracts with a medical practice, then that's an independent contract. I mean, there isn't very much literature, thought about why we draw this categorical distinction for discrimination. For whistleblowing, there are some courts, the New Jersey Supreme Court in particular, took a case where it should have been independent. It was an independent. Insurance company hires a doctor, says you must be a doctor, you must have your own practice. You can't work for us more than 20 hours a week. And your job is to look at medical claims and tell us, are these valid claims or not? Advise the insurance company. And this guy publicly complained to authority about the billing practices of Prudential Insurance. And they fired him. He said, I blew the whistle. I'm a conscientious employee. There's a statute, Conscientious Employee Act, New Jersey. And Prudential Insurance says, you're an independent contractor. You're not an employee. And if you read the majority opinion in this case, I don't think they really disagree, but they said the test under that statute has to be attuned to the purpose of the statute, which is we want people to come forward with knowledge of the internal workings of the company that are evil, violation of law. We want them to come forward. It shouldn't make a difference that under the restatement he'd be an employee. It's enough for this statute. The most recent development is an interesting one. California, not in the lead, actually, Connecticut, Massachusetts, and New Jersey. There are others, but I've only followed those. And California. California, in a Supreme Court of California, in a case called Dynamex, took a slice of California wage law and said, well, who's an employee? There's a whole subsequent history because Uber and Lyft came up with, $20 million, I think, to put something on the ballot that which passed, which changed the law. Now it's in litigation up to here. Forget California for the moment, but other states, at least the most prominent ones are Massachusetts and New Jersey, have adopted what's called the ABC test. And it cuts the Gordian knot. It says if you work for somebody else, if you do work, you are an employee. Unless the following three conditions are met, but all of them have to be met. It's conjunctive. I'll just read quickly what the ABC test, if I can find it. I know it's here. Such individual has been and will continue to be free from control or direction over the performance of such services. Well, that's the right of control test. You're free of control. And under the common law, that would probably be enough. No. Also, such service is outside the usual course of business for which such service is performed, or is performed outside of all places of business of the enterprise for which. In other words, you're not part of the regular operation of the business, even though we don't control you. And such individual is customarily engaged in an independently established trade, occupation, profession, or business. So you must be well acknowledged that you are an engineer. We don't control you. We hire you for your engineering services. We don't control what you're telling us, right? That's obvious. But you can't be an integral part of the business. Well, that's the engineering. It's a design. Of course, now you're an employee. You failed the second. All three prongs have to be met, and you must satisfy. And you are engaged in independently established trade. Well, what if it's not well recognized trade? Well, then you can't be. There's been Guy Davidoff has an article in the UK journal, the Industrial Law Journal. He and Penina Alan Shanker, they like the ABC test. They tweak the last category. They're not too happy about how it plays out in some freelance occupations. Well, that's the bottom line. The takeaway is that there is no, some countries, seem to have our law drives a dichotomy. You're either an employee or an independent contractor, nothing in between. Some countries have three categories. Italy has a paura subordinate. You're next to being subordinate. Germany has the Arbeitnehmer ähnliche Personen, you're a worker-like person. Sweden and Canada have what they call dependent contractors. Yes, you meet that's that second, the B part of the test. You're not you're wholly dependent on this. Right? You're not truly independent. Britain has the three categories. It's that middle category that's been the subject of litigation in the High Court and the Supreme Court. But we have two. You're either an employee or not. You're either covered or you're not. But we have, on the one hand, for collective bargaining purposes, a unspeakably troglodytic approach to who's an employee, who's covered by, who can collectively bargain and who can't. And we're just stuck with that. The others, we have far more liberal tests for, even the federal government does, a more liberal test for wage an hour, for who gets overtime. It's not so much minimum wage. There aren't that many minimum wage workers, about 4 million minimum wage workers. But if you are an employee, you're entitled to time and a half for overtime. If you're not an employee, you're not. And so an employer can work you for 60, 80 hours a week at your regular rate. Whereas if you're an employee, it has to add a 50% premium after 40 hours. So for that statute, it's important. And state law is increasingly playing a role here for wage payment, wage and hour law, retaliation law, anti-discrimination laws. And as I said, several states have adopted this far more flexible and realistic. If you think there is a difference, the question is, who is this statute really concerned about? Are we concerned about petty entrepreneurs who, by being entrepreneurs, we think they've assumed a certain risk? And employees who don't, we assume that they have to be protected from those risks. That's the kind of question that some of these statutes are asking. So it's true, it's a yes-no kind of test, but with a great deal of flexibility and difference between the states on how they approach it. Now, I'll conclude on my skepticism about the gig. Look, it's not just the gig. The kinds of cases I'm talking about are very, very serious cases. If you're not subject to wage payment law, we have all the states say an employee must be paid the full wage due, right? If you don't pay it, you're stealing. It's called wage theft. Punch out from you're at Walmart, punch the clock, you're off the clock. Would you be so kind as just to mop the floor for 10 minutes before you leave? Stock a shelf for a few minutes? What's the harm? The harm is they're stealing your labor. Okay, it's only 10 minutes. How many employees does Walmart have? 1.1 million employees. There's a study by the Economic Policy Institute that shows that if you look at their numbers are good. I think they're a liberal think tank in Washington, but no one criticizes their data. They conclude that American workers are stolen, have their wages stolen, shaved, and to the tune of $14 billion a year. Billion. That's about 22% of the take-home income of the lowest tiers of American working society, the people who can least afford to lose that money. It's being shaved. The drive for employers to cheat is a business model, and one way they can cheat is by saying, well, these aren't employed. I don't owe them overtime. They're independent contractors. Now, some states have enacted so-called misclassification laws. It's a separate action if you've misclassified the worker. So I think if you ask me my opinion, I think this issue of who's an employee and who's not is a very, very, very important, because billions of dollars involving millions of people involved. But it's not so much the gig economy. These are not gig workers. These are regular workers doing janitorial, sales, The gig workers, I'll close with that. There's a member of the economics faculty of my school, just was appointed. He's doing fascinating work. How do we know who's a gig worker and what significance it is? Well, if you are an independent contractor, the employer does not withhold your taxes. If you're an employee, you sign it's called a W-2 form, and you get a stub, and your tax withholding goes to the Federal Revenue Service. If you are an independent contractor, you get a 1099 form. You must pay your income tax. And since you don't pay Social Security, the employer is not paying Social Security on an independent contractor. You have to pay your Social Security plus your own. You're self-employed. So as an employer, you have to pay the 6% on what you're paid. And as an employee, you must pay this. It works out to about 15%. All this is filed with the Federal Tax Authority. These are not individually identifiable data, of course. But the aggregate data is. So you can find out how many people file 1099s. How many independent contractors are there? Because their taxes are paid, what did they make? What he found, this is an ongoing enterprise, what he found is that are there a large number of American workers who do gig work, who file? The answer is yes. And what surprised him, what surprised me is just from tax data, it's an enormous number. Something like over 50% of the American workforce, maybe close to 70%, is paid, files forms for their pay, their income, doing gig work. How many make a living at it? For whom does the amount of money become a livable income? About 2% of the 2.5%. A lot of people will sit at a bus stop and do Mechanical Turk, or or maybe even take a neighbor to work on a platform basis, or walk a dog. But they don't make a living at it. It's a few extra bucks. But the amount of people who depend on it for a living, and those are the ones I think society should be concerned about, are not insignificant. 2% of the labor market is about the same as what we have in agricultural work. We have a labor market of 140 million, so 2.5% is not insignificant. But it's not the wave of the future. And it hasn't been going up. It has not been going up, despite the pandemic and the great resignation, that we talk about. So I thank you for your patience. I hope that you found this informative of what another large and pro-business jurisdiction does. And I'm open to discussion and questions.